Good afternoon. Thanks for joining us. I'm Ken Kirschenbaum. We have Mitch Reitman and Dennis Stern who are going to assist today. I see Victor Harding maybe we'll let him participate later. He's got his mic ready to go, but no camera. So today's webinar is, if I can get it up here, guarantee and holdback issues and valuation in era of coronavirus and liability exposure. So today's webinar is about selling alarm accounts or buying alarm accounts. The format today is, by the way, is I'm going to go through a webinar fairly quickly, and a PowerPoint rather, and then I'm going to open up the mic first to Dennis and Mitch, and anyone who wants to participate, just let us know, and we'll be happy to have you. So if you're selling or buying alarm accounts, this webinar should have some information for you. So the issue that we're really focusing on today is the reduction of the purchase price. And when you close, obviously you've agreed on a purchase price, you've agreed on a format for how you arrived at a purchase price, and what happens after that is that during this period of closing and then adjustment period, there's a reduction of purchase price. Occasionally, the purchase price increases. That's possible. Sometimes sellers are out there generating additional accounts, or they've held back some and they have additional accounts, and the purchase price ends up being more than it was at the closing. But most cases, there's a reduction in sales price as time goes on. There are three things that bring down the purchase price, and we're going to address them. The guarantee, a breach of representations and warranties, and post-closing seller performance requirements. These are three separate items that need to be negotiated in the contract that gets entered into between the seller and the buyer. So the guarantee is usually, almost always, tied into this question of attrition. A buyer and a seller know that there's a history that company has of attrition. You could anticipate that attrition is going to be a bit higher than normal when a buyer takes over. The negotiations that have to take place during the contract period, pre-signing contract period, obviously, is from a seller's standpoint, how do we take steps to prevent a buyer from causing higher attrition? And that is important to a seller, because a seller is almost always guaranteeing the attrition. So whatever multiple we use, let's use a multiple of 30 times. That makes the buyers happy on this webinar, or I could say 40 times, which makes the sellers happy on this webinar. If an account is lost during this guarantee period, then the account RMR, which was used to calculate part of the purchase price, is then calculated using the same formula to reduce the purchase price. Let me clear up one issue right from the get-go, and that is, what about revenue that was generated from the closing date till the time that the subscriber has canceled? Well, sellers sometimes say, I want a credit against the holdback, and the guarantee rather, and the buyer says, no, we've serviced the account during this period of time and we're entitled to the money that came in, and it has nothing to do with the contract adjustment, purchase price adjustment, and they're right. So typically and customarily, it's the buyer who retains any money generated during the post-closing period, and as long as the account is lost during this guarantee period, there will be a purchase price adjustment. there are other potential risks that are negotiated during the contract period that get looked at after the closing. And these are representations and warranties that are made by a seller in the contract that a buyer asks for or demands, and then looks at very carefully post-closing. And if there are discrepancies between what was represented and warranted, then if you have a litigious buyer, you could end up in a lawsuit where damages are demanded because there's been a breach of these representations and warranties. So some of the things that could be demanded during contract negotiations might be attrition history. Well, we never have more than 5%. Okay, we want a representation. You've never had more than 5%. And what happens is the buyer accepts that, but then after the closing, all of a sudden they've had a 10% attrition during the guarantee period, and now all of a sudden they'll say, by the way, now we want to search the last 5 years pre-closing, and we want to see your attrition history. Now we're going to first look at it. They find the attrition history is more than 5% each year. Well, that's a breach of a representation and warranty made by the seller, and it subjects the seller to a lawsuit and damages. The same with employee retention. Maybe there's been a representation. I've had the same employees with no turnover for at least 5 years, and then the buyer finds out that that's actually not correct. Perhaps there's been the buyer may demand some representations with respect to operations. How many employees have you had? What of your employee expense? What are your other expenses? What receipts have you had in the last 5 years? We want to be able to determine what kind of profit you've been making, which incidentally are all irrelevant when a buyer is purchasing the assets and not the company itself, the seller himself, and therefore these representations and warranties should not be made. All they are is a trap for the seller. So you need to be careful about it. Post-closing performance by a seller is the next item that could end up in purchase price reduction. Maybe a seller's agreed to reprogram accounts to the buyer's central station, designated central station. Maybe a seller's agreed to sign subscribers on new contracts provided by a buyer, or maybe even the seller's contracts. Maybe a seller's agreed to complete work in progress, or maybe a seller has agreed to work as a consultant, to work as a salesman, to work as a customer relations person. Maybe it'll be very vague what his duties are. Maybe it'll be vague how often he's supposed to report to work. And maybe that vagueness will lead to different expectations by seller and purchaser and subsequent litigation after the closing. So those are the three things that can cause a problem. So let's go back to guarantee. The guarantee. The guarantee is not the same as the holdback. Those terms are not interchangeable. The guarantee is simply what it sounds like. The seller guaranteeing the accounts will stay with the buyer for a period of time. Of course, there are caveats that need to be added to that guarantee. The guarantee is never absolute and unconditional. There are always conditions attached to it, and all of those conditions are a matter of negotiation, as is the length of time of the guarantee. So the typical guarantee is 1 year on these deals, a 12-month period, and you sometimes see a lesser guarantee period, sometimes 6 months, and you also sometimes see a period exceeding 1 year. Sometimes it's 18 months, sometimes it's longer than 18 months. Now, I can tell you that when it's under 1 year or more than 1 year, you're generally dealing with an unreasonable seller or buyer, because typically it's 1 year. You have to have a real good reason for deviating from that 1 year. Now, there are deals that sometimes come along where the guarantee is eliminated because it's taken into account the anticipated attrition, and it's adjusted in the purchase price or in the multiple. Either way, it's the same thing in a way. You get to this, whether you adjust the purchase price or you adjust the multiple, you still affect the purchase price, right? So here, sometimes we've done deals where we say, okay, we don't want a guarantee, and guess what? We were offering you 38 times. Now we're going to go to 36 times, but there's no more guarantee. And there's an analysis done, and if the seller believes that the historical attrition is going to be somewhere within that reduction in purchase price, then they may agree to it. So it removes the risk for both sides on what is the attrition going to be, and therefore that type of deal, by the way, helps avoid disputes that can come about post-litigation period, post-closing, I mean. So the holdback, which is sometimes synonymous with the guarantee, is really the collateral for the guarantee. So the holdback is what is a money that's not paid at the time of closing. The buyer will almost always simply not pay it. Some sellers will ask that it be placed in escrow. It pretty much never is. A buyer feels they want to hold. They know there's going to be some attrition. Everybody knows there's going to be some attrition, and so they just don't want to have to pay it. The typical holdback could be or is 10%. So you have a 90% on closing, 10% is not paid, and it's called the holdback. And it is there to guarantee or collateralize rather the guarantee, but it should be limited to the guarantee for attrition. The holdback should not be available for breach of representation and warranties or post-closing performance items that the seller is obligated to do. You don't want to have that holdback out there collateralizing every single agreement, covenant, or condition that a seller has made in the contract period, contract negotiation. You want to limit it to the attrition. So sometimes the 10% is increased. It's by the way, it's almost never decreased. So you won't see a deal with less than 10% unless you're not going to do a guarantee and you're not going to have a holdback. Oh, where you won't have a holdback, by the way, is when you have a seller holding the paper, the seller financing the deal for the buyer. So instead of 90% of closing, let me just get rid of this. 90% of closing, there will be no collateralization of the guarantee, because the payout itself is the constitutes really the holdback. Now, if you're having a deal financed, it might be wise for a seller to say, listen, we're doing a deal and you owe me $2 million and that you're going to wind up paying me over a 5-year period, 3, 5, 7-year period. I'm not going to have a guarantee out there for that length of time. So if I'm going to be giving you a guarantee, I want to limit any adjustment to 1 year. After the 1 year, the payments that you owe me are not subject to any reduction. And so that needs to be negotiated. One of the things that we'll hopefully discuss a little bit later is whether the holdback to collateralize the guarantee under current economic situation is sufficient at 10%. It might be that it needs to be increased from 10% because we can anticipate some additional attrition based upon what's going on with this virus situation and the economy having been shut down. So if you have a buyer that insists that the holdback also serve as collateral for representations and warranties or post-closing performance, you need to be, the seller in particular needs to be very careful how this is negotiated. It can't be anything that is favored by a seller, because all it can do is cause a bunch of issues to arise post-closing that will permit a buyer to avoid having to pay whatever's been held back from the purchase price and challenge the purchase price, and also potentially go beyond the holdback amount. One of the things that I didn't mention is deals also have to be very carefully structured in terms of, is the holdback the limit of the purchase price reduction, especially for the attrition issue? It's not always. It's very simple. Sometimes contracts sometimes will say the holdback, the guarantee is not limited by the holdback, and conversely, it might say the guarantee is limited by the holdback. So that's one sentence that completely changes the deal. You need to be very careful about how you raise those issues. Dispute resolution is an important issue when there's a dispute. A lot of these deals are small deals, relatively, especially in terms of cost of litigation. And if you've got a holdback with $100,000, for example, which means typically that would be $1 million deal, you really have a problem litigating an issue like that, because by the time the lawyers are finished with you, the holdback may end up going to the lawyers instead of either the seller or the buyer. Yes, even when there's a legal fee included in the agreement. The point is that we want to be able to resolve these issues quickly, efficiently, and inexpensively. And so we include a arbitration clause in all of our deals, and we have a company that we use that is able to deal with these issues very, very inexpensively. As a matter of fact, it's even designed to allow the alarm companies, two alarm companies, to just submit their dispute even without lawyers, to just get it resolved. And often it'll be resolved quickly and as I said, efficiently. So all of our contracts contain that arbitration clause. Our alarm contracts are between you, the alarm dealer, and your customers, not a buy-sell deal. We don't really favor giving out contracts for that. We have to design those contracts for each deal. We also have our concierge program, which is on our website, and I urge you to go along with, get involved with that. And now I am going to open this webinar up, and Dennis and Mitch, you guys are already unmuted, right? Hello?
Yeah.
Okay, so Dennis, what don't you agree with? You can start on slide 1 if you want.
How long do we have? One thing very interesting to me the holdback, I don't, in all my deals, I've never had a separate guarantee on the accounts. To me, the holdback is essentially a guarantee. In terms of other reps and warranties, usually we get into indemnification provisions, which I know you don't like, and those are circumscribed. So for instance, if there's a $5 or $50 claim, there's a basic pocket that claims have to exceed X amount before indemnification even comes into the pictures to get rid of the nickel and dime stuff. On the holdback, two things. One, never do a deal where the holdback isn't limited to the 10%. And you're right, 10% is standard, or at least used to be standard. And the other thing is, in creating the holdback provisions, we exclude certain things like anything, people canceling because of rate increases, people canceling because the buyer decides they don't have your contract, they want all the customers on Kirschenbaum contract. Some customers may then not sign and rather leave. And so we have those kind of exclusions in there, or if the buyer doesn't provide a proper level of service and a customer cancels, that's on the buyer's nickel. Because one of the problems with the whole concept, quite honestly, is the buyer is running that book of business, right? So cancellations may go up, but the question is, how much is that due to the buyer's action? And it's easy enough for a buyer to do it, because if he loses an account, he knows he can dip into the holdback amount. So we exclude as much as we can, and then we have a dispute resolution provision in there, which say, they're going to look at the data, they're going to talk, and if they can't resolve it, then I agree with you, it should go to arbitration. And in all my experience, I don't think there are half a dozen where they haven't resolved, because there are always some questions on some of the accounts. And in some cases, buyers generally don't go for that in a big way. There's also a provision that they provide cancellation information every 30 days. They don't like to do that. And if there's a cancellation, the seller can get on the phone with the buyer, because the buyer obviously doesn't want the seller to make deals, to see if they can save an account. And they also, you're right, they won't get credit. Very unusual to get credit for the money the buyer has taken in before the cancellation. But we also have a provision which says if somebody moves out and there's a re-sign, or the people who move out go to a new location and use this company, then that doesn't count as a cancellation, and the re-sign usually has to be done within 30, 60 days of cancellation.
Right. Before Mitch goes, I want to just clear up something that I've tried to make very clear, and you seem to skip over it. So I think you started by saying in all your deals you don't have any guarantee, you just have a holdback. Is that what you said?
Right. It's not in terms of we're guaranteeing these accounts. To me, it's the same difference, as long as it's limited to 10%. But to me, we have a holdback provision with an attrition factor in there, and you can call it a guarantee, you can call it a holdback, you can call it whatever you want. It gets you the same place.
Well, you can call it whatever you want. You can call an apple an orange if you want to, but it's not.
Right.
So the question is, it is most certainly a guarantee. And whether you have that in your contract or not, if you don't have that word in your contract, it seems to me that you're going to have a whole lot of other words that mean the same thing as a guarantee. Because a holdback is nothing, says nothing more than we're going to close, we're going to pay you 90% at the closing, and we're going to pay you, we're not going to pay you 10% at the closing. We're going to pay you 10% a year later. That's the holdback. But
no, that's not the whole holdback. The holdback says we're going to pay you 10 later, subject to reimbursing us for cancellations. And
Yes,
then you
yes,
need
yes.
the whole network of exclusions from what are cancellations.
Before you get to the holdback, however, and we won't have to beat this horse to death, but before
Okay.
you get to a holdback, you have to have the guarantee first. The guarantee by a seller is, I guarantee that, subject to certain conditions, technically, hopefully worded as conditions precedent to all you lawyers or would-be lawyers out there, we're going to reduce the purchase price if these accounts are lost during this period of time. That is the seller's guarantee to the buyer. So we have to start with this guarantee. If you don't see the word guarantee in your contract, then unless Dennis wrote it, it's messed up and you need to fix it, okay?
Well, we obviously will continue to disagree, but
Yes.
it's not what you say it is, but that's fine.
All right, so you're gonna have the guarantee and it's gonna be collateralized by this holdback, okay? By the way, you don't need a holdback because you can simply have the guarantee. You can have a guarantee, seller says, I guarantee these accounts, for a year. And meanwhile, pay me 100% at the closing. And if I owe you any money, I'll send you a check at the end of the year, or you'll come and sue me. But that doesn't mean that you have to sit and hold my 10% for that year. We'll deal with it at the end of the year. So
Good luck finding a buyer who will agree to that.
Well, wait a minute. If you have a big enough seller who's staying in business and you're not worried about it, there's no reason why you couldn't do that. But again, of course, that's not typical. Usually you have the guarantee and you have the holdback. Mitch, what issues do you have with?
Well, the first thing I've got to say is I do agree with Ken. There's holdback and there's guarantees, and you don't want, if you have excess holdback, and I'm going to go through a few reasons why you would have it other than attrition, you don't want the buyer to be able to get to that excess holdback for attrition. You want to limit your attrition, say to 10%, have the 10% number in the holdback, and that's all they can come after for attrition. If attrition goes higher.
That's understood. When they ask that it applies to reps and warranties, the answer is no.
Yeah.
It just applies to canceled accounts.
So I want to go through a few examples of where you could have holdback, not for attrition, and not for a guarantee, but because some of the things came up. We're working on a transaction right now where they have about 400 3G radios that have to be replaced. The sellers agreed to replace them, but we've written in the agreement if they can't get them replaced, the buyer's going to charge them a certain amount of money per 3G radio, and that's going to be done in holdback. They're either the seller can continue to convert these radios, but they can't get them all converted, and the buyer's out some money to convert them. They're going to take that out of the holdback, the excess holdback, but they can't use that holdback for attrition. They can't use it for reps and warranties. They can't use it for other things. That holdback is assigned directly to those radios and nothing else. An issue I'm seeing from time to time too, because we're accountants and when we do due diligence, these are not situations where we're brokering the transaction. These are situations we're representing a buyer. We ran into one the other currently that we had a fairly good feeling they weren't paying their sales tax. And in the state where they are, the sales tax can follow the assets and attach to the buyer. And so there's a disagreement about how much they may owe the state in sales tax. And they said, well, we'll just pay it when it comes around. We said, no, that's not quite good enough. We think this could be a $140,000 item. So we're going to hold back $140,000 in extra holdback. When you get a letter from the state that says everything's hunky-dory, which is called a clearance letter, we'll release that $140,000. If you get a letter from the state that says you owe 70, we'll release half the $140,000. So there's another type of holdback.
Setting up a separate holdback for that. The other question I would have is, in most states where they can charge the buyer for unpaid sales tax, there's a way to get a certificate or a statement or a document from the state, which
it's called a clearance letter.
How much sales tax they owe. And once you get that certificate, or if it says they don't owe any, that will solve the problem. But if
then it's called a clearance letter, and the problem here is if it's a company that's never had an issue with the state, it takes about 30 or 45 days to get the clearance letter, and the state says, okay, we're okay. If it's a company that has had issues with the state in the past, and the state does think they may have issues, they usually launch an audit and investigation before they give the clearance letter out. That could take 5 or 6 months. And in this case, we're fairly certain that the state is not going to just send out a clearance letter and say, here, they owe us this amount of money, or they owe us what we found. We think the state's going to say, hey, we haven't been out to see them in a year or so. We're pretty sure they owe us some more money. And so we're going to go do an audit. And that could take 5 or 6 months. So that's why we put the holdback in there. We're not going to get the clearance letter. We know it's not going to happen. It's not going to come in 30 days or 45 days. It's probably going to come in a year. And so the holdback is waiting for that clearance letter to come. When we get the clearance letter and they say they owe us $80,000, we take $80,000 out of the holdback and we move on. But it's great to get the clearance letter. That's definitely a good point. Every transaction should have a clearance letter in a state where the taxes follow the transaction, but they're not as easy to get as you may think when the state suspects
For instance, in New York, if they don't issue it in 30 days, you're off the hook anyway.
Yeah, and this isn't New York where this state is, but I know this state, and I know that they're going to conduct an audit before they issue the clearance letter, and they're going to say, we're not going to give it to you.
The approach to have a separate holdback for that makes a lot of sense. Yeah.
The other issue is, central station swings. I still run into customers that have accounts at a central station that need to be reprogrammed, so there's holdback for that. Ken talked about excess attrition due to COVID, and I'm under the impression that most of the customers are going to cancel because of COVID issues and lockdown issues, either canceled already or going to cancel in the next 3 or 4 months. I don't see a reason to have an entire year of holdback to cover extra issues over and above the 10% related to COVID. If I was negotiating a transaction and there was additional attrition guarantee or holdback due to COVID, I would ask for a shorter term, maybe 6 months or so. I don't think that you're going to see a year from now a customer saying, well, we lost some money during the COVID scare and we're going to cancel. And I don't think that'd be very material.
Wait a minute. What about what you were doing a deal right now? And let's say you're going to go to contract within the month of June, which gives you another 20 days or so. And the question is, can we anticipate higher attrition in the next 12 months than historically? I think it would be, I'm pretty sure it would be a good bet that there's going to be higher attrition. We know that there are many alarm customers that are not going to be able to open. And we also know that thanks to government stimulus, some of them may be able to open, but we don't know if they're going to be able to survive, because it's a whole new world out there it's a whole new world out there for retail. That may not affect, that can't be good for the alarm industry. I mean,
and the question is, will this condition continue to last another year or 6 months? And that's a decision that a seller has to make. If the customer, if you do the deal and close it at the end of June, is that customer going to cancel? If you give them an extra 6 months of holdback to cover COVID-related attrition, do you think that's going to happen by December? I would say it's probably pretty reasonable to expect that. Do you think it's still going to be lingering into next spring and people still canceling? So it's just a decision you need to make.
Mitch, you're not gonna have deals that are structured that say we have a 1 year guarantee, but only COVID-related closings are only guaranteed for 6 months. That's not what you're going to have. You're going to have a 1 year guarantee, and then the question is going to be, are we going to have more cancellations within the next 12 months than we normally have, even though the cancellations, as you point out, will probably be within the next 4 to 6 months, that they will be the ones that never reopen or fail once they reopen. But still, we don't have 6 month guarantees. If we were going to have a 6 month guarantee, we would say, yeah, we think there's definitely going to be more attrition in the next 6 months. But I don't think we're going to separate. We're just going to have that 1 year guarantee, and you're going to wind up having a lot more attrition within the next 4 months. I think that's what I anticipate.
Well, the art is what you can negotiate.
Very wrong to just assume that there should be a larger holdback. First thing is, what is their current attrition rate? If it's a 6% or 7% rate, that's obviously very good. if it has kicked up to 8 or 9% under industry standards, that's still very good. That wouldn't justify kicking a holdback up to 20%. So this kind of, oh yeah, we're going to automatically kick it up because we all know the virus is out there. And if you have to kick it up because you see an incremental cancellation rate that has come about, then I think at least kind of consistent with what Mitch has said, there should be a look at 6 months to see if that cancellation rate has dropped down back to the old rate they used to have, or if it's still on the increase. If it's dropped back, there should be a partial refund of this beyond 10% holdback. So just to say, hey, we got COVID, so you got to give me 20%, I don't think is appropriate unless somebody can document that your cancellation rate has really gone very high.
So wait a minute, you guys don't think, forget about buy sell deals. I got a collection department also that we're looking forward to the next 6 months. What you don't anticipate greater customer fall off in the next 6 months than typical?
In the next 6 months, but not for the entire next year. And what I'm saying comes back to, I want to keep as much of that holdback away from my buyer as I can. And so what I want to do is take this extra over and above attrition guarantee holdback and put it in a shorter term, so that I don't have my buyer able to take that and use that against other items and other attrition. I want to say, look, we're going to go back and look at this, just like Dennis said, at 6 months. And if there's been over and above the 10%, we'll let you have some of that to cover the COVID, but we want the rest of it then. We don't want it sitting and lingering around for another 6 months and letting the buyer be able to get to it. It comes down to the art of the transaction, how you can negotiate it, and what the buyer's willing to accept.
And nobody is saying there isn't a kick up in cancellations. We all understand that. But before you say instead of 10%, I need 20%, you got to take a look at how big for that individual company, given their customer base, how big that kick up has been. And as I said, if they had a very good cancellation rate of 6 and 7%, if it now goes to 8 and 9, companies that are bored with 8 and 9 cancellation rates still only have a 10% holdback. So you got to see what the impact of this is.
Well, that's
numbers.
Well, that's not fair. You can't say that, because first of all, I want to get back to what Mitch said about I think what he was saying is, if it's typically a 10% holdback, and now we're doing a deal, and let's say I'm representing a buyer, I might want to say, well, I want 20% holdback because I anticipate because of COVID that there's going to be a lot of drop off. So I think what Mitch is saying is, well, okay, we'll give you the 20% holdback, but after 6 months, we want 10% of that holdback back. Because within the next 6 months, you're going to have your drop off from the virus issue. And then after that, we're back to normal. Now, okay, so that I understand. That's what you're saying.
That's what I said.
And I'm not saying the buyer's going to give it to you. I'm saying you should ask.
You got to look 6 months and adjust.
Dennis, what you're saying, though, is a little bit different. What you're saying is, if a company has a 6% historical attrition rate,
right.
One company has 6, one company has 10% attrition rate, okay?
Mm-hmm.
So what you're saying is, well, we might have a different holdback to collateralize the guarantee of those two different deals. But guess what? I don't see that typically. What I see typically is that adjustment is made in the multiple, not in the guarantee or the holdback.
I don't generally see that. I mean, if you want to get into that, the whole question is, why do we even have guarantees? Way back when, companies were sold without guarantees or holdbacks. And yes, if you're concerned about the performance of the book of business you're buying, instead of offering a 40, why don't you offer a 37?
Right.
And forget all the BS at the end. That's fine. Unfortunately, that's not, quote unquote, what people typically do these days. But I agree with you on that. It should be a reflection of the value of the book of business.
So give me a minute. Let me address that. So let's go back to the guy with the 300 3G radios. He says he's going to replace them. He says they're going to be perfectly good accounts. Are you going to reduce the multiple based on the fact that he's because he hadn't replaced them yet? Or are you going to say, okay, we trust you that you're going to replace them. We're going to give you the full multiple. But if you don't, we're taking additional holdback and we're going to keep that. If you try to adjust the multiple to account for something that he can cure and he can make good, then you've deprived him of his multiple. If you do it with holdback.
I'm going to answer your question. Counselor. If I was representing the buyer, I would hold back on all those accounts. I wouldn't pay anything on those accounts until they were reprogrammed. As they were reprogrammed, I would pay for them.
But you don't reduce the price. Or a lot of times when I see these transactions, the buyer has the ability to replace the radios and get them working properly and working correctly. So the buyer's got a cost, but the seller's saying, I'll replace them so you won't be out the costs. And if I'm the buyer, I'm gonna say, okay, I just want to make sure that I'm made whole for my cost to replace these radios.
How do you make sure? How do you make sure? You make sure by holding back the money for that account. That's how. By the way, I want to point out something. The most important thing I'm going to say today, and I know these two gentlemen are going to agree with me. Everything that we are talking about, whether we're agreeing or disagreeing with each other, highlights the importance of contract negotiations, because every one of these issues that we are talking about are the subject of negotiation. It's the subject of negotiation if you have a lawyer or an accountant and consultant sometimes aware of what the issues are that need to be addressed. Because if you don't have industry savvy people, no one knows about these issues. No one thinks about all these issues.
Yeah.
And that's the kind of mess that's what causes a mess later on when you haven't thought of these things and all of a sudden they start popping up and you haven't really dealt with them in your negotiations. So whatever issue that we raise can be and should be addressed during negotiations, and it should be spelled out very clearly in the contract that gets entered into, so we know how to deal with each issue.
Yeah. This is going to surprise you, but I agree with you. How about that?
Okay.
I've been saying for years, you got to have an attorney who has experience, not only M&A, but more critically in this business, because there are things that need to be negotiated, which if they don't know the business, they have no clue. The prime example is, how do you define RMR? They don't know what is acceptable, what's not. You can spend hours and hours with their comments dealing with it, which in the business make no sense. Obviously, the person who hired that attorney is paying for all of that. And Mitch, on your thing with the holdback for the radio, again, I agree with Ken. I wouldn't pay for those accounts until they get switched out. And then obviously, if the buyer has costs, they come off of what he's going to pay for them. And most buyers, I would think, if they have any industry experience, would like to do the switch out themselves, because that way you can also do add-on sales and other things, and you can make sure it's done right. I'm not sure why, especially with a significant number of accounts, you would want the seller mucking around with accounts that you just bought. That doesn't make any sense.
Dennis, as you said, you'll be representing the buyer. What I was talking about, if I'm representing the seller, I'm not going to, as Ken said, try to negotiate the buyer's position for him. If the buyer's willing to buy those accounts, but he wants to reduce the price or do something to cover the radios, I'm going to say, we'll give you some holdback to cover the replacement of the radios, but I'm not going to tell the buyer, don't buy those accounts. If I got a buyer that's willing to do it, it's not my job to tell him that he may be making a mistake to buy the accounts in the first place. My job is to make sure my seller gets as much money as possible in the sale, as long as he approaches this honestly.
From a seller's perspective, I understand that. From a buyer's perspective, I'm not sure I would want the seller mucking around on all those accounts. I think the answer is, hey, we're going to change them out. you're going to get billed as a reduction of what we're going to pay for you once they get switched out. Because if there are a lot of residential accounts, that could take a long time. You know, people don't
You're
always
right.
come in the house right away. So
You're
you
right,
could
Dennis.
have
And down the hall, I've got two hats, my buyer's hat and my seller's hat. You're wearing a buyer's hat there. I'm wearing a seller's hat. Saying,
out of that.
All right,
I
guys,
want my money, and I
let's-
want to be clear.
Let's hear another voice who's so anxious to participate. I think he's already talking to himself. Okay, Rory, I'm getting ready to unmute you. So
Uh-oh, you're going to
you're
be on.
unmuted. You're unmuted, Rory. Are you there? Rory, don't complain that I didn't
Hello.
unmute. Oh, you're there.
I'm
Okay.
here. I'm here.
Are you off?
I was,
Are you off the treadmill?
I'm here.
Rory? Okay, Rory's off the treadmill. Well, Rory, this is your opportunity. Tell us how the three of us don't know what we're talking about.
You know what you're talking about. Of course you do. I was talking to Eileen, your gal, when you were talking. I was on another call when you were talking.
My gal, do you know what that's going to cost me? My gal, that's going to cost me $200,000, Rory. Thank you.
You didn't say it.
Eileen, yes, I was talking to Eileen. Yes, I was. And I wasn't listening. I'm sorry. So she was talking with me about whether I wanted to be muted or not. You have a question? I wasn't paying attention because I was talking to someone else. I'm sorry.
Well,
Rory, here's the question. When are you going to refer one of your deals to me? There's the first question I have for you.
Get in line. I think Dennis is first. Dennis is in line
Oh,
first.
okay, good. I like it when Dennis gets a deal.
Me
And
too.
All right, Rory, so you don't have anything to add to what we've been talking about?
No, but I think, I like to keep it simple. To look back in 6 months, I hear Dennis, what he's saying. 6 months, you might have to give a little more holdback at this point in time with the COVID deals. And I've done that. I've got a deal right now, 17% holdback that I have. And what I did is, instead of having to go a look back 6 months from now, I did a 5% bucket. So I gave him 17.5% holdback to the buyer. Okay. But I said, I want a 5% holdback for whatever reasons, a bucket, a basket, whatever you want to call it. I prefer doing it that way, unless there's less work later and we can keep it simple. That's I ran this by Dennis last week and I thought it was a good idea.
I think Dennis, are you the guy that came up with this whole bucket of what? I'd like to.
Well, I mean, to me, the bucket or whatever it consists of means a buyer is willing to, in effect, accept a 12% holdback instead of a 17% holdback. So,
well, what it means is
the issue. What is he really looking for? If he's really looking for 17%, he's not going to accept a bucket. Okay,
listen, I don't understand about the way of a 17% or this or that or a bucket. This is what it sounds like to me, and this is what it reads like too. Okay, I guarantee the accounts, but I'm not going to guarantee the first 5% that drop off. Or I guarantee all my reps and warranties, but if you suffer damages, I'm not going to cover the first 25,000 of those damages. What kind of nonsense is this? I will not accept any deal with a bucket, period.
Well, so traditionally the bucket was if a phone bill comes for the seller that you didn't know about, and it's for $125, it's in the bucket. You just pay it. You don't worry about addressing the reps and warranties and making adjustments, and that can get up to $5,000 or $10,000. But there's a bucket in there, but you're not going to get nickel and dimed over small things.
Why?
Nickel and dime. Nickel and dime. All right, here's what I'm going to do on my next deal. I'm going to put a bucket in the broker's agreement. Well, the first 10,000, that's in your bucket. Forget it. Yeah, you like that.
The very good reason to have buckets on reps and warranties, as I said earlier, to avoid the nickel and dime claims like $125 telephone bill that pops up later.
Well, that's a bad example. That's a bad example.
On the holdback, to me, a bucket really only means you're reducing the amount of the holdback. Now, if a buyer is okay with that, why wouldn't you just say, instead of 17% and the first 5% is a bucket, why don't you just call it what it is, which is 12%? The other question is, hey, Rory, did you get a cap on the cancellation, so that's can't exceed 17% or 12%, whatever the
Yes,
actual.
yes. Yeah, you taught me that. You taught me make sure you get a cap too. Yes, correct.
And you
I
should
did. Yes.
always get a cap
Well,
on
one
that.
thing-
Yes, you told me that. Yes, I did.
Or whatchamacallit, should always have a cap so
Corey, is
that.
that the extent of what you learned from Dennis? I'm just curious because you said you got that one from Dennis. Is there anything
Well,
else?
Dennis,
We-
Dennis,
we've all
I've done
gotten a
deals
lot
in
from
the
Dennis.
past. Yeah,
Let-
yeah,
let me-
that's his method.
Ken, let me real quickly before we run out of time. There's a few things you brought up that I want to reinforce that are really critical. One is you talked about if the buyer causes the attrition, that you should have something in your agreement to relieve the seller from having to be liable for that attrition. And believe it or not, we've had really good luck when those provisions have been in agreements, being able to go through the buyer's central station records and find out why the customer actually canceled. A lot of times it's a question of the customer moved and the buyer could have put a new system in or activated a new system for the customer. They didn't do it. So that's one thing you should always have in your agreement. You should say if the buyer causes the attrition, make sure the lawyer does it, has it in there so you have something to do. The other thing you mentioned was taking a note from a buyer, and especially if it's for substantially the purchase price. You need to be very, very particular in the agreement how that note is going to be how it's going to work, and how it can be offset. We had to go to do some litigation support for a seller that the attrition was higher than the buyer thought it was going to be, and they refused to make any payments on the note, which is for 80% of the purchase price. And it was very loosely defined in the purchase agreement, and we had a really hard time getting the note readjusted and redone. This is another reason, and a lot of times when I see these notes, it's a seller that is sold to a buyer without an attorney, without any kind of agreement, or a very loosely written agreement. You've got to make sure you address these non-standard terms very, very closely. And the last thing I want to mention too is the asset allocation. The way you allocate the gain on the sale of these assets is super critical, and you need to make sure your accountant knows how to do that. There's a form right here, the 8594, that both parties are supposed to fill out after the sale. You really need to agree to how you're going to allocate purchase price before you do it, because we've got one right now where luckily they called us in ahead of the transaction. It would have cost them $100,000 in extra taxes if they would have done it that way. So make sure your accountant has been through transactions before. Make sure your attorney is a transactional attorney. Don't get your brother-in-law that's a divorce attorney or a title attorney down the street to handle your transaction. You'll end up having more issues than you think you'll ever have. And we tell people, and I'm sure Ken does and Dennis does too, we do oil changes, we rebuild engines. Change your oil, you won't have to rebuild your engine. Get somebody that knows what they're doing to get in this transaction up front, not when it's all devolved and you're headed toward litigation. Get it done right so everything's spelled out and explained.
That's certainly very good advice.
On that point, Mitch, I would caution people, sellers very much to give notes, number one, and certainly not for any large percentage if they're going to do it. And two, if they give a note, it better be secured by some of the assets that are being sold to give them some additional protection. And of course, if there's bank financing, the note is going to be subordinated to the bank in any case. But when you start giving large percentages in the form of a note, that is not very advisable to do. I had one client who was going to take it payable over 10 years from a small mid-sized competitor looking for buying them, and that's just doesn't make any business. Forget about the legal sense; doesn't make any business sense. So if you give a note, it has to be for a very small amount for a very short time, and you should try to securitize it by specifically some of the accounts being sold.
I think that's good general advice. I must say I have had deals with long payouts, very long payouts, where the seller held the paper. They're not as common as the other deals, but and the reason for it was that the multiple was higher, and there was a good interest rate factor built in, and the seller actually preferred a steady stream of money. And they weren't worried about the seller the buyer going out of business. And Mitch, I'm not clear on this one. I'd have to defer to you. If you're getting paid out that way, are you declaring the income from the sale in the year you get paid, or do you have to declare it all in the year you sell?
You have an option unless you declare otherwise. It's treated as an installment sale and you report it as you get paid. But
Right.
you have, I haven't seen a seller do it yet. You can claim it all in the year you do the transaction. The problem is with holdback and guarantees, you rarely ever know what the total purchase price is going to be, even with a standard
No.
transaction, there's holdback.
Right. Well, if you have a 1-year holdback and a 10-year payout, you know, you have a
installment
set
sales.
amount after the first year. And if you're earning, let's say you could get 6-7% right now, Dennis, or even more, and you're not worried about the seller going out of business. Might not be a bad investment for you if you feel safe that way.
Yeah,
Two things to ask your
but
accountant.
You don't know that he's not going to go. You know, if you have a 10-year payout, nice stream of income without a doubt. But why wouldn't you take the money up front and go invest it, you know, with a reputable investment company, and you probably can earn your 6%, and you don't have the risk that after 7 years or something, this guy's going to go belly up, and what do you got? You got nothing.
Well, if you can get me 6%, Dennis, send me wire instructions, and I'll be happy to send you my money.
I'll be glad to do it. Be glad to do it.
Me too. Send me
What-
too. Yes.
What am I buying? Your condo?
Although the reason,
I'm a good investment advisor, and if you don't have one, I'll be glad to share the
Well,
information.
I can't seem to make 1% on my money, so I don't know what you
Really?
want.
I could find you an 8% rate, but the risk would be so high that the only thing would be risky, less risky than would be taking a note from a buyer.
Yeah.
There's a lot of risk on an 8% return. There's a tremendous amount of risk in a buyer. Look at the S&P 100 from 20 years ago and tell me how many companies are still there if you're going to take a 20-year note or a 10-year note.
Well, I wouldn't go for 20 years.
Yeah.
You know, right now I'm limited by my own lifetime, so they're going to be short. They're getting shorter and shorter.
Sweet.
Before you take a 10-year note, look at the S&P 100 and tell me how many companies that were there 10 years ago are still around today.
Yeah. All right. We're approaching the hour. We made it. Kept you guys entertained for an hour. We didn't get a single question, I must say, so I'm not sure why. We did get a thank you. I'm starting to actually like these BS sessions. Maybe we'll just start doing them on a regular basis. And Dennis, maybe you can invest in a radio station and we could really broadcast these things all over the place. How's that?
Let's put a plug in for next Tuesday.
We're going to sell advertisement space to ADT and SimpliSafe. Maybe we can make a lot of money on these. We should have Dennis, why don't you have those contacts, or Mitch? You know, we're going to let them pop up their ads during these things.
Okay.
Okay, but before we go, let's put a plug in for Dennis and my session next Tuesday. We may have to mute Ken for that session. And what I want to change it to is the Dr. Laura's book, 10 Things Women Do to Mess Up Their Lives, 10 Things Alarm Company Owners Do to Mess Up Their Companies. And we're going to talk about that and how you can, it'll be kind of a continuation of this, but what you're doing now that's going to mess you up if you go to sell your company in the next 10 or 20 years.
Well, it's going to be different than this because I promise Mitch and Dennis are going to take the lead on that, not me. So the what are those ratings? The TV ratings? I forgot what they are.
Nielsen's?
The what?
The Nielsen's or the PG
Nielsen rating. We'll see how the Nielsen ratings go. But it'll be the Dennis and Mitch show. I'm going to just take a back seat. Probably my contract ads will pop up every once in a while.
And we'll be talking about that next week and what an issue that can be. So
yeah.
We'll
sign in next week. I think it's on next Tuesday, I think, right?
Right.
The 16th. The
same
16th.
bat time, same bat station next Tuesday.
Right. Everybody come back, bring your friends, usual charge in place. Okay. So everyone, thank you. And thanks Dennis and Mitch again for participating. Rory, thank you for us coming on and giving us some words of wisdom. And
thank you, sir.
We look forward to having you on more webinars. So Rory's going to get back on the treadmill. Dennis is going to go back to sleep. And Mitch, I don't know what you're going to do.
What are you doing, Mitch?
I'm going to get some work done this afternoon.
He's going to look at tax return. He's going to look at tax returns. I'd rather kill myself. Oh my God.
Happy trails, guys.
We're signing off.
Okay.
Thank you. Bye-bye.
Thank you, gentlemen. Thank you. Bye-bye.